All right, so good afternoon, everybody, and welcome to our second installation of our Thirsty for Knowledge Thursday presentations that we're giving from McMurray & Schuster. I have on the line with me the practice head of our compliance and privacy practice, Nick Whistler. Nick, if you'd like to say hello.
Hey, everyone. Thanks for jumping on, and looking forward to the webinar.
So where the idea came for today's webinar is that as we were coming up with topics for our Thirsty for Knowledge Thursdays, we kept talking about this would be a good time to do this, or this would be a good time to do that, while we've got an economy that's in shutdown, and it's conceivable that a lot of people have some extra time on their hands. And instead of having individual webinars for all of those, it would be a good time now to do this. We decided to give an overview of those in one presentation. And this is the result of that brainstorming amongst our compliance and litigation teams here at McMurray & Schuster. So I'd just like to start by saying that, now would definitely be a good time as we're sheltering in place to take a look and take stock at the things that our companies are doing in the compliance area. What's working, what's not, what's current, what's outdated, what the strengths are within your individual companies, what the weaknesses are, where there's opportunities, so that when we come out of this economic shutdown, we're really poised to take advantage of the opportunities that are sure to be there. Using compliance as a way of driving marketing that will be effective and not cause risk for companies that are engaging in that marketing is an optimal scenario for companies in the marketing and advertising area. It's been our experience that companies that have a well-documented compliance program that meet certain requirements that we're going to talk about today tend to run into trouble far less often than those that don't. And then if they do run into trouble, they're far more likely to be able to get out of a class action litigation or a CID or a complaint filed by a regulator than those companies that did not. And to get out of those, especially in the class action area, with the hope that you can resolve those matters without having to enter into litigation. So that's our goal today, to discuss those areas that are most critical to focus on and hopefully provide you the insight that you can take advantage of safe harbors and policies, procedures, and concepts that will keep you out of trouble. So with that, Nick, if you'd like to give an overview of the agenda.
Yeah, so quick rundown here. As Michelle mentioned, the value of having policies and procedures in place cannot be overstated. So we're going to talk briefly about some ideas around that and maybe updates, things that you should look to see that are covered in your policies and procedures, etc. And then the other thing, in addition to having time to kind of reflect on current status, that we're seeing right now is a bunch of companies maybe pivoting a little bit on how they operate. So it's more difficult to meet with people in person, whether it's door-to-door or retail or what have you. So we're seeing actually an increase in the desire for cold calling, which has been largely dead for a long time, an increase in text campaigns, lead generation for inside sales activities, those types of things. So we're just going to kind of go through some of the key compliance considerations for those areas where we're seeing to make sure that they are covered in your policies and procedures, or if they're not, that you can think about compliance and getting those implemented. Kind of going hand in hand with the lead gen is this concept of due diligence. So it's really important if you're getting leads, if you're working with other companies, certainly not limited to lead generators, but just this concept of due diligence and making sure that these third parties aren't going to create unnecessary risks for your business. It could be, if you're a platform provider, that your customers. It could be if you're a BPO type of company that you're subcontracting work. There's a number of different scenarios to consider, but the lead gen is the one that's kind of driving a bunch of concerns right now. And then Real briefly, we're going to give a quick update on privacy issues with the CCPA taking effect this year and things to be thinking about there. And we'll close out with a rundown of kind of action items and top priorities as you leave here of things to be thinking about and going back and checking on. So Michelle's going to dive into the policies and procedures.
So sorry about that, Nick. I'd muted myself. So let's dive in with the policies and procedures. And I should start by saying that, there are safe harbors on the federal and state level, and they vary in their requirements, but all of them have some core concepts that we want to talk about today. I should also say that with the federal DNC Safe Harbors that I'm going to talk about here in a minute, they have been rarely successfully used in litigation, but I have a theory for why they've been rarely used successfully in litigation, and that's because the companies that are taking actions that are aligned with DNC Safe Harbors rarely get into trouble with either the regulators or with TCPA litigation or other marketing and advertising type of litigation. So while there aren't a lot of great examples of where it's been used, I would tell you that that's because the people that are using it, the companies that are using it, aren't going to run into those situations. So first with DNC Safe Harbors, specifically, they require that there be written policies that comply with the national do not call rules. So you have to have a documented policy, a documented procedure for how your company is going to comply with do not call regulations. It would have to specifically address scrubbing. It would address the types of exemptions that your company may be able to take advantage of for DNC scrubbing, and that's specifically with the outbound telemarketing types of calls. Additionally, you're required to train employees. You're required to have an internal do not call list that's honored. And you're required to be able to show that you have scrubbed in a manner that's required, basically on a monthly basis. I would also say that while that's the safe harbor for do not call in the federal level, the principles about having a documented compliance program that documents the policies and procedures, trains the employees on it, follows through on those policies and procedures through monitoring and then addressing any issues that are identified. That's really the core structure of any effective compliance program that a company should be engaging in. We have found that companies that have compliance manuals that document all of those core processes and procedures in the compliance department and throughout the company, and that they can show that they have trained employees, that they are far less likely to run into problems of the regulatory or civil litigation front. So during this time that companies are either shut down or employees are working from home, where there may be additional time to do such a thing, I really encourage you to take a look at what's the compliance manual, what are the policies and procedures that your company is operating from, not just in the do not call arena, but in all of the marketing and advertising that your company is engaging in. We frequently assist companies with these types of compliance manuals. We frequently will update them. And I will share with you, our experience has been that companies are really good at initially drafting compliance manuals, but then the actual procedures change down the line, and frequently companies will not go back and revise those compliance manuals. So now is a really good time to take a look to make sure that your actual procedures that you're engaging in within your company follow those policies and procedures that are documented in the compliance manual.
Yeah, Michelle, and one thing just to kind of layer on that, just for everybody here, it really is important to keep those up to date. We had several changes last year that were of significance, things like, for outbound campaigns, the fact that certain states imposed their do not call restrictions on B2B, business to business calls, some disclosure changes just in the last month. There's been a few updates. South Dakota has added some additional disclosure requirements for telemarketing calls. West Virginia has additional record keeping requirements now for any of your call recordings and maintaining those for at least 5 years. So these things are constantly changing, and you want to make sure that you're staying up to date and updating your policies and procedures to account for that. And to the extent that you have, additional downtime right now, that might be a good opportunity to do those things. So as I mentioned earlier, it's kind of interesting. The whole industry had gotten away from cold calling for lots of reasons. The leads that you were losing by scrubbing out numbers on the DNC lists, and that's both the federal and the 12 states that have them. Just the difficulty in getting people that were interested in your product or service. So the conversion rates were low, all those different things. But as I mentioned, when it's more difficult to get in front of people in person, we have seen a renewed interest in this, particularly among companies that went door to door or had some type of retail locations that maybe they sold from. So if that's something that you're thinking about, or if you're a call center, your clients are thinking about, some key things that you should take into account are, of course, the DNC lists and scrubbing against those. We're not going to have any type of consent to call cell phones using a dialer. So you really need to make sure that your phone system is a non-ATDS and that you're not unnecessarily exposing yourself to risk on that front. Also keep in mind that several states have their own restrictions on calling cell phones. So even if you're not using a dialer, there's a handful of states, Arizona, Louisiana, New Jersey, Texas, and Wyoming, for example, have restrictions on calling cell phones. I think a lot of people probably have been paying attention to the New York state of emergency recently, and its prohibition on making unsolicited calls there. Louisiana also has one, but it's not been triggered yet, so you still can call as normal there. But these are the types of things that you really need to be thinking about. And then the last one relates to registration. So when we do registration analyses for companies, we generally look for two types of exemptions. The first is the company is exempt. So it's a publicly traded company, or it's a call center whose customers are primarily exempt. And so there's what we call the 75/5 or 575 exemption, where you can kind of piggyback those client exemptions. But beyond that, many companies rely on campaign-specific exemptions. So all of their campaigns are qualify for some type of exemption because there's consent or there's an EBR or something like that. So when you're doing these new cold call campaigns, you need to think about whether you are relying on any of those types of campaign-specific exemptions, and if so, know that these new campaigns may trigger additional registration requirements. The other thing that we're seeing is an increase in demand for text campaigns. So, for most of these, the companies are trying to get written consent. They're using these, blast text programs, but some are also trying to do this on a more manual basis. So if they don't have valid written consent, they're trying to find a text platform that they feel comfortable falls outside the scope of an ATDS. They're manually initiating these texts. And when you're doing that, the things to be thinking about are whether there's any state-specific restrictions again. There are a handful, I won't go through all of them, but there are, maybe somewhere in the neighborhood of 8 to 10 states that have restrictions that require either an existing business relationship or consent. That varies by state to send those. So even if you're not using an ATDS platform, you still need to worry about those state-specific rules. If these are marketing texts, under the TCPA, a text is a call, so you have to comply with do not call. So that's the importance of your EBRs. All the calling time restrictions would apply to texting with other types of things. So keep that in mind. And then the last thing is these aren't legal requirements, but you will want to give thought to the CTIA best practices and its short code monitoring handbook, which govern how you should be setting up text programs. It may not be possible to perfectly comply with these unless you're getting that type of TCPA written consent up front, but you'll want to take into account what you can comply with. These are things like some type of opt-in if possible, certain disclosure requirements about how to opt out, and help and stop instructions, linking to privacy policies and SMS terms. So there's a bunch of things that would go into this. And so again, because they're not legal requirements, you'll just need to give some thought as to what your policy will be around those, and understanding that if you don't fully comply, the main risks are, potentially having your text blocked or getting blacklisted by the carrier. So not so much dollar damages, it's more about operational considerations if you don't comply.
All right, so tagging on to that, if you're engaging in cold calling and trying some different types of marketing techniques, you're probably looking at retaining a lead generator or starting your own lead generation efforts. And you're doing that so that you can meet the consent requirements in the state and federal regulations that require certain types of consent, whether it's you're using an automatic telephone dialing system under the TCPA to call cell phones, or you're using pre-recorded messages, or just that you don't have an exemption from scrubbing against the do not call lists. Having a consent lead from a consumer is a way that you can call them without having to worry about those types of compliance concerns. So let's talk a little bit about lead generation and what it takes to get written consent. And I know a lot of the folks that are on this phone call are sophisticated compliance officers and are familiar with the requirements for prior express written consent and consent, but we wanted to highlight some specific areas where we still see a lot of problems, and that the consent is not being obtained in a way that is effective and would provide you with a defense in a lawsuit that you were calling a consumer without the proper consent or without the proper ability to call without scrubbing against the do not call lists. The first is the specific sellers. I'm sure you guys have seen it as well, lead generation forms that purport to get consent for a very large group of companies that are identified in the consent form as marketing partners. And in some of these lead forms, it's not even specific to an industry or the type of call that a consumer would expect to receive. And that's something that the regulators have been paying very close attention to lately, and also something the TCPA Class Action Plaintiffs Bar has been paying very close attention to. What they're alleging is that the consumer was not given clear and conspicuous notice as to the fact that they would be even called, let alone that they would be called by what could potentially be hundreds of marketing partners that are identified in that list of marketing partners. So it's very important that as you're out there and engaging in lead generation, that your company is recognized as the company that is getting consent from a consumer who's filling out that form. And that is something that is clear and conspicuous and obvious to the consumer as they're completing those lead generation forms. Some of the forms that have caused problems are in this clear and conspicuous arena. For instance, we've had court decisions that have found that a lead generation form did not get consent because the actual consent language was required scrolling for the consumer to scroll past where the consumer was inputting their information and data, or that the font was too small, or that there wasn't enough contrast in the language to let the consumer know that they were providing this type of consent. So it's really important that you not only get the language correct, but that it is appearing in a way that a reasonable consumer would understand that they were going to receive telephone calls as a result of filling out that form. We get a lot of questions about whether a checkbox, and I should say an unchecked checkbox is required on these lead generation forms. And there is really no exact right way to do this with a checkbox, or maybe having a submit button that the consumer hits to submit their information. what's important is that there's some combination or some verbiage on that lead form that notifies the consumer again that they are going to receive calls. For instance, if the submit button said call me, that would put a consumer on notice that they're going to receive a telephone call. If there's a checkbox and it's unchecked and next to it says I consent to receiving a call, that would be an effective way. So very critical that you have these types of lead generation forms reviewed by competent counsel, because it really is a determination of whether a consumer would expect to receive a telephone call from submitting a form. Equally as important is that there be proof of consent. So if you get the form exactly right, but you're not maintaining the correct records, so that if, God forbid, you do run into issues with a TCPA lawsuit or a regulatory action, that you are not able to produce the consent form in a way that is effective, then it's as if you don't have consent. This will happen sometimes when you hire vendors that are maintaining those records. We have seen situations where those vendors go out of business and the seller did not have copies of the lead forms before they did, and obviously that causes significant proof problems. So in the lead generation space also, frequently we're thinking about getting consent in order to meet the TCPA consent requirements, especially to use an automated dialer to call cell phones or to leave a pre-recorded message. But there are DNC considerations also. So even if you are not planning to use an automated dialer or a pre-recorded message, if you don't have an exemption to the do not call rules, then you're going to need some type of consent in order to call that consumer. So don't think that this is only about the ATDS issue. It's also about do not call. Also, with regard to the seller being named in the consent forms, I wanted to point out a 2006 FTC ruling, actually not a ruling, but a staff opinion from the FTC that addressed the concept of lead generation forms, and specifically this was in the mortgage broker arena, where a lead generation company would use a form that would allow the consumer to request competing loan interest rates and other loan options from various lenders. And so they would fill out one form, and by filling out that form, they were also provided with a list of potential lenders that would be calling them about the loan they were requesting. But the form also said that they would, the consumer would only be contacted by a certain number of potential lenders. And so when the FTC staff looked at that, they said, you know what, the consumer has a reasonable expectation that by filling out this form, they're going to be contacted by lenders. They're going to be contacted by lenders that are in this list, and that they're going to receive no more than 4 calls as identified in the lead generation form. So there are ways that if you don't know who the specific seller is, that by identifying the potential pool of sellers or call originators, the folks that would be placing the calls, and limiting the number of those calls, that you could still meet those clear and conspicuous requirements and the consent requirements. Important to note that with the TCPA private right of action of $500 to $1,500, if you are relying on lead generation forms and you don't get it right, and every call is potentially a violation, then very quickly those damages accumulate to an amount that cannot be calculated by a calculator. So really important that you get these right. Also, if you are relying on an inquiry EBR and thinking that I won't need a consent form because somebody is making an inquiry by filling out this form, there are states that do not recognize an inquiry EBR, which is on the federal level. That's that you can call a consumer within 3 months after an inquiry to your specific business. Well, there are a number of states that don't have that inquiry EBR. The ones we generally point to are Indiana, Wisconsin, New Jersey, but there are other states as well. So make sure that if you are relying on an inquiry EBR, that you know what those states are that don't honor it. And again, make sure you have proof of that EBR, proof that an inquiry happened, or proof that you had done business with the consumer you're calling within the applicable time period. On the federal level, it's 18 months. On the state level, it can range from 6 months to also 24 months, some of them. But in any case, important to have that proof and be able to produce it.
Yeah, so one thing I just wanted to mention, I'm going to get through this slide pretty quickly so that we can get to our due diligence and other things that I think maybe have a little bit more of a pressing need. But as I mentioned earlier, people are adapting. Things that we're seeing is work at home agents. We're seeing branch offices or people that are generally going door to door starting to make phone calls again because of the restrictions on in-person. So one thing to keep in mind when you're doing that is that it's going to be more difficult to have oversight over those campaigns. The work at home may be a little bit easier because they can still log into systems, et cetera. But you know, when you have people making calls using their own cell phone or using, you know, just a desk phone in some branch office that's not connected to a main system, you know, the lack of call recording can be a struggle. Staying on top of what they're saying. Are there any consumer protection concerns? Are they getting, you know, valid authorizations for payments? All of those types of things become more challenging. So the takeaway here is really just training and having good policies and procedures are so critical. There's probably going to be some missteps along the way. If you acknowledge that early, but you focus on your training and your policies and procedures, you'll be in a much better spot to isolate those issues and not have them blow up into very large compliance concerns. So just something to think about as you're rolling out more of a decentralized compliance program. And I will also say that that's not a good long-term solution, right? That's maybe a bridge gap to get us from now until things get more back to normal, but just stay on top of those as much as you possibly can.
So due diligence and contracts and working with vendors, lead generators, subcontractors, all of those types of companies, really important that you do some due diligence if you're bringing on a new lead generator or other subcontractor. On this list are some of the types of things that you want to look at. The reason this is so critical is because there is vicarious liability under most of the regulations that are going to apply to you. I will tell you the most important thing in the due diligence after you have reviewed a company and identified who's going to comply with what provisions of the law, because those can be assigned to various companies, that you have to monitor that company. You have to monitor complaints. And if you start to see issues, make sure they're addressed immediately. The Dish Network case, that is kind of the seminal case in vicarious liability, which resulted in Dish Network having $280 million in fines and penalties. It was mostly because the court observed that Dish Network received complaints but did not take action to correct those, and those complaints were about their vendors. So really critical on the due diligence front.
Yeah, and you know, a compliance webinar wouldn't be complete these days if we didn't at least remind you of the privacy and data security issues that are continually escalating. You're probably aware, but just a reminder, the CCPA is in effect right now. The AG cannot enforce it until July 1st. There's been many efforts to get them to push that back with everything that's going on. They've come out publicly and said that they do not plan on pushing that back. So we need to be thinking about July 1st as that enforcement date. They have issued 3 versions of draft regulations to implement the law. The most recent just closed a comment period at the end of March. So we are still expecting to get some type of final regulations probably in the spring. And it's really important that you're on top of the CCPA and its impact on you. I'm not going to go through all of it, but the things that you need to be thinking about are, you know, privacy policies, your point of collection disclosures. If you're getting information from consumers, that could be over the phone, that could be online, it could be in person, to the extent that you can still meet with people in person. You have to provide rights to consumers, so there has to be a way for them to request certain things what information you have, for you to delete, for you not to sell their information. And those of you that are service providers, it's interesting. Generally, you don't think of like asking for contract restrictions upon you as to how you can and can't do things. But in this context, you actually want them. If you don't have restrictions in your contracts with your customers saying that you only can use their data on their behalf and that you won't use it for your own purposes, or use it for other customers, you do not qualify as a service provider, and you'll have direct CCPA obligations instead of very minor indirect obligations. So really think about that. The CCPA also has a private right of action for data breaches that involve certain types of data. So these would be things like socials, credit card information, other types of data. And it is likely that this will become a significant boon for class action plaintiff firms, similar to what we saw in the TCPA. So we expect a lot of lawsuits under this. If you are a seller, you can imagine that you'll get hit with those lawsuits directly. If you are a service provider, it's likely that if you are the cause of the issue, your customers will seek indemnification against you. And lastly, if you're handling data about residents in the EU, don't forget that GDPR, which is the European Union's very robust privacy regulation, has a lot of restrictions, including much more on service providers than CCPA does.
Hey, Nick, as we go to the last slide, I just want to remind everybody, if anyone has any questions, you can type those to us in the chat section that appears on your screen through the platform. So don't hesitate to ask questions. We're at the end of our half an hour, but we're more than happy to stay for a few minutes extra and answer questions.
And we could also handle those offline as well. So last thing here is just kind of in terms of top priorities. Many of these things we touched upon already, but just kind of a rundown here. Really important to update your policies and procedures, whether they're outdated, whether they just need to be updated with new laws and regulations, maybe just improve them from top to bottom, something to be thinking about right now. If you are considering new types of marketing campaigns, could be telemarketing, could be other types of marketing, having a checklist to go through what should happen before those go live, really effective way to mitigate risk. We've used those for years and can certainly help out with that type of thing. Again, I mentioned training earlier, really critical. It's both part of the safe harbor defenses. It's also a way to really prevent issues from happening. And those who do training well are the companies that generally have far fewer issues. I cannot harp the due diligence enough. If you are doing more lead gen than you have done in the past, you have to review these lead forms. That's just the beginning of it, right? That's the bare minimum that you should be doing. You should be monitoring, like Michelle said, on an ongoing basis, but you have to review those lead forms up front. It's very, very important. The CCPA, just getting on top of it, knowing what data you have, where it goes, how you're using it, and getting all of these consumer-facing disclosures and request forms and things like that in place, very important. If you don't have a data security plan, you should look into that. I think most companies generally have something, but that is another area where we've seen a handful of people struggle. They don't have formal policies around their data security. And then the documentation, if you can't prove compliance, especially with things like consent and the other things that we talked about, it's not going to be effective. So you really need to make sure you have good documentation as well.
All right, so with that, I'll remind everybody that we are doing these every Thursday. Next week, it will be advertising laws implicated by COVID-19 and some of the prohibitions that are existing out there or other concerns in this current environment. The next week, we're going to have a review of recent class actions and lessons learned through those. We'll have various presenters from the firm that will be handling those. As Nick mentioned, if anybody has any questions as a result of the topics we've brought up, feel free to reach out and contact us. This webinar will be available as a recording on our website. Also available is the webinar that happened last Thursday that dealt with work-at-home agents and employment issues as a result of work-at-home agents. So thank you for joining us today, and we look forward to seeing you on another one of these in the near future.
Thanks, everybody.